Demystifying Law School. Why were you assigned the reading you were assigned? Right now on this video. Don't make the mistake of assuming that you were asked to read the case in front of you because it accurately reflects current prevailing law. I mean, sometimes that's the reason, but often it's not. I mean, there's really only one reason to assign a case, which is that it provides a great learning opportunity. But there are many ways in which a case can provide a great learning opportunity. And understanding that can help you a lot with your learning and your mental well-being. So let's get into them. Number one, it's leading/controlling. Some cases aren't just examples of the law, they themselves are the law. I am the law. But whether it's likely you're reading that kind of case will depend a lot on which course we're talking about. If it's a subject that is federal and the U.S. Supreme Court is in charge, like civil procedure, constitutional law, copyright law, administrative law, then it's very likely that you're reading leading/controlling cases. But if you're talking about property, torts, contracts, that's state law. There's no single court that's in charge of that across the United States. So any given case you're reading almost certainly is not leading/controlling. Number two, it's a good example of the rule. This could be the reason a case was assigned in any class, but it's probably especially likely in a class like sales, secured transactions, UCC course, also property, torts, contracts. But this sort of thing gets boring fast, so that is probably not the explanation for all the cases in your casebook. Number three, it has a good explanation of the rule/law/doctrine. The fact is, sadly, there's fewer of these cases generated by the courts than you might think. Number four, it has interesting facts. Everybody loves a good story, and we want you to be engaged. So we might assign a case just because it involves captivating human drama. We might assign a case that involves rock bands, something appealing to the younger generation. Inevitably, this will be music that came after our time, but before most of you were born. Who here is a fan of the Smashing Pumpkins? Maybe it concerns events recently in the news, such as the Clinton administration. But beware, when a case is picked for having interesting facts, there can be serious trade-offs. It might have a bad explanation of the law. It might have bad reasoning. Number five, because it's famous. As a torts teacher, who am I to skip Paulsgraf versus Long Island Railroad? I can't do that. It's too famous, even if it makes my head hurt every time I read it. But if a case is assigned because it's famous, everything else about it could be a trade-off. For example, it's atypical. It's no longer good law. It's opaque. It's convoluted. What? Paulsgraf? Convoluted? Number six, it's for fostering discussion. Ultimately, many of us in legal academia became professors precisely because we love listening to ourselves talk. This is Professor Eric E. Johnson. But sometimes we get bored with that, and we want a good classroom discussion. Number seven, it's irritating, grating, annoying. In other words, it doesn't sit well. You know, law school really is not about memorizing laws. It's about learning how to analyze legal questions, learning how to construct arguments. Sometimes a case that gets under your skin and bugs you is the perfect vehicle for that. Number eight, it's puzzling. What does it all mean? Don't ask me. I'm not here to tell you what to think. I'm just your tour guide on a journey of learning. Well, look at it this way. This is graduate school. If it made sense undergrad to force you to take philosophy and ponder questions that have no answer, then certainly there's some value in a law school education for having you think over some questions that really don't seem to have good answers. Number nine, it has good analysis. I love a case where the court is intellectually candid, rigorous, thorough. It's not so much the rule or the facts or the result, it's how the court gets there. Closely related to that is number 10. It has bad analysis. If you were only to have examples of good analysis, your learning would be stunted. A case with bad analysis is a wonderful learning tool. Dissect it, look at it under the microscope, figure out exactly where it went so wrong. After all, the only thing better than learning from your mistakes is learning from other people's mistakes. So for your internal peace and well-being and your flourishing as a young legal mind, don't forget, there are many reasons you could be asked to read what you've been asked to read.